Good afternoon to you all. I am Dr. JP Singh. Welcome to today's lecture. The topic is concept in forensic medicine. We'll be covering the topic with all these four topics, and this is uh, the professional misconduct, warning notice, professional secrecy or confidentiality, and privileged communication. Moving ahead, professional misconduct. What we call as professional misconduct, it's a misconduct or poor conduct done by a professional person in his profession. It is also called infamous conduct, being the conduct done by the individual which is getting a bad name for the profession. So moving ahead, any conduct of medical practitioner which might reasonably be regarded as disgraceful or dishonorable. That means disgraceful and dishonorable, who will decide? It will be decided by professional men of good repute and competence who are practicing parallelly to that person in that area. That act of the individual or conduct of the practitioner will be decided by those person as misconduct or infamous conduct. If someone is conducting in a bad manner or bad way or professionally non-competent manner, that means he'll be issued a warning notice. As the name suggests, it's a warning notice. Warning notice means any notice issued by the competent authority for the act done by a person in the profession to warn him for the actions. That means warning notice, these are issued by the authorities time to time regarding the acts which will be included in the list as professional misconduct or infamous conduct. The practitioner observes certain prescribed rules of conduct contained in the medical ethics published by National Medical Commission or State Medical Council. So the council time to time keeps on giving example of the offenses or example of the acts which will constitute serious professional misconduct. That means the list is never a complete list, which at that time issued will include the acts which have been mentioned in previous list and the latest list. So the list is never a complete list, and the council can consider any form. The council can consider any act done by the individual which when alleged, the word is alleged, which when alleged as professional misconduct and assessed by the competent and reputed person, reputed professionals in that area. And though it may not be under any of the offenses mentioned in the notices issued previously. So the act which is under consideration now at present may be a professional misconduct and it may not be in the list. Then anyone who is found guilty of any of the following acts may include the act of commission or omission, act done by the person, the doctor concerned, or the act not done by the person. That means he was supposed to do some act, take some action in that situation, but he has not taken that action in that situation. That will be included in infamous conduct and he will be issued a warning notice. It includes improper conduct with the patient. There is always a professional relation between a doctor and the patient. If the individual is not maintaining that professional relation with the patient, or improper association, taking the person not as his patient, having some improper association will be considered as infamous conduct and issued a warning notice. Again, conviction by the court. If some doctor has been convicted by the court for some act done by him in his practice or outside the practice, he will be issued a warning notice. Next is contravening the provisions of drugs and cosmetic acts. That means generally the prevailing practice in our area is some professionals, some medical professionals, they generally keep some drugs with them. Some medicine they prescribe and give by themselves. Apart from that, if they are prescribing drugs which are not supposed to be there in their practice and they are either selling or prescribing, that is contravening the drugs and cosmetic acts and hence they will be issued a warning notice. Next is issuing a false certificate, false, misleading, or improper certificate to a person who is not there in contact with the contact means professionally contacts with the practitioner. Hence, issuing a certificate which is false or misleading, writing something which is not concerned or not about actually true about the person. It comes under Section 197 of IPC, and warning notice may be issued to the practitioner. Next is issuing certificate of efficiency to unqualified or non-medical individuals. Issuing such certificates, again, it is an act which should not be done by medical professionals. Hence, they may be issued a warning notice. Advertising, it's a very big thing. Advertising means everyone is advertising himself, but do not get associated with anyone, anything. If you are advertising through someone, some manufacturing firms, directly or indirectly, that means you are giving benefit, you are giving privilege to that firm towards the patient so that they are getting profit from their product or their medicines. This is also called biasing. You are biased towards that individual or that firm, and hence you are discarding the benefits to the patient from the society. Then there is dichotomy. Dichotomy or fee splitting, as the name suggests, it is splitting the fee by the doctor between him and the other individual, or it is also called as taking or giving commission benefits to a professional colleague or manufacturer. This is again a professional misconduct. It should not be practiced. A warning notice may be issued for the same. Covering means assisting someone who has no medical qualification, non-qualified person who has been working somewhere, and a medical professional who is qualified is giving a cover. The unqualified person may be performing surgery, or you may be, not you actually, or the alleged professional may be sending patient to him for the surgery. So it is again a professional misconduct. And the next is disclosing the secrets of the patient. As a patient who comes to you, he tells you about his issues, and if you are disclosing the information received in that communication to some unconcerned person, it is again an act of infamous conduct. So the list of important issues, the list is maybe, it is not complete list. So first is adultery, second is advertising, as already discussed. Third is abortion, and abortion is unlawful abortion, right? Then there is association with unqualified persons in professional matters. Already discussed, should not be associated with the person who is not qualified in the concerned matter. The addiction and alcohol, they go hand in hand. Then there is a term called professional secrecy. It is secrecy of the profession by the doctor concerned when he is in practice with the patient. So it's an implied term. That means the doctor is in contract with the patient. The doctor is in contract with the patient for any information when the patient comes to him with consent and mentions his problems. The doctor is in contract not to divulge any information received in that contract. The relationship of doctor and the patient requires the trust, the confidence, the fidelity and honesty. That means trust, confidence, fidelity and honesty in the relation between the doctor and the patient should not be broken. The doctor is obliged to keep the secrets all he comes to know concerning the patient in course of his professional relation. That means in that case, in that particular case with the patient, he is supposed to keep the things secret, not to be told to anyone. Everything discussed is confidential. Disclosure leads to failure of trust and confidence. Disclosure leads to failure of trust and confidence, as a result of which the doctor may be sued in civil negligence case by the patient. So the disclosure should not be involuntary. Here we have written voluntary. That means if it is there, it should not be involuntary, that you are telling the information of the patient to anyone where it is not required, harmful to the patient and not in the interest of that person or the public. The information, that means, should be under some rules. Which are those rules? We'll move ahead and see. Statement made bona fide upon any subject matter by the doctor to the concerned authority. Opposite to professional secrecy is privileged communication. Opposite to professional secrecy is privileged communication. Professional secrecy, we are keeping the information with us only, right? And now we are telling the information of the patient to someone. So where we can divulge the information, these are the situations. Before divulging the information, we should persuade. That means persuade the patient and take the consent. This is legal term. We should take the consent of the patient that we are about to tell the information received or the findings of the case with the patient to the concerned person. Disclosed, the secrets or the information disclosed for protection of the interest of the individual, society, but not to other persons. So the doctor is not liable to pay damages when he is telling the information to the concerned person or authority after taking consent from the patient. It comes under privileged communication, right? So privileged communication, these are the cases where we can divulge the information. Where we can divulge the information, it is infectious diseases, servants and employees. Infectious disease, like some individual, he is staying in a hostel and is found to be suffering from some infectious disease like tuberculosis. In this case, the information should be sent to the authority in the hospital. Servant and employees, some individual coming to you for examination, and during examination you find out that he is suffering from seizure disorder, and the individual is likely to be employed for driver, as a driver of school bus. That means he should not be employed as a driver of school bus. In such case, this information should be told to the employee. Notifiable disease, few years back we had worldwide outbreak of COVID-19. So any case of COVID-19 during that duration coming to us in practice should be notified to the concerned authority. That means in this case it was Government of India. Venereal diseases, this thing, it is between two parties who are getting engaged or married in some cases or employed somewhere. So in such cases, the information should be informed, the information should be given to opposite party. Next is patient's own interest. If patient is coming to us and he is found to be, for example, if he is found to be colorblind. So in such case, we should tell the patient that you are colorblind and you are not fit for the present job, right? You may go for other job where this disability is not hampering your actions. And again is negligence suit. This is for saving the doctor himself. When some cases of negligence are filed against the doctor, in such cases, doctor can divulge the information to the authority. And suspected crime, this is very important. Suspected crime, it is the information to be given without any delay under the law to the concerned authority. In this case, it is police. If they are asking permission, if they are asking some information in writing, it should be given to them in writing. Last and last, not the least, is courts of law. So whenever we are getting some summon or some order from the court to divulge some information about the patient, in these cases, we should give the information in the manner as asked by the patient. If we have been asked to come to court and tell the information or tell the facts, we should go to court and tell the facts. Or if they are asking for the records, we should supply the court with the records. Thank you for the patience. Kindly like and subscribe and share. Thank you.